What if we agree to everything in mediation and then my spouse or ex just ignores it? I hear this question or a version of it almost every week, and it's a completely fair concern. And the answer, once you understand how the sort of legal arc of mediation actually works, will put your mind at ease. So in this video, I'm going to walk you through the complete path from mediation agreement to enforceable court order. Step by step, no jargon, no surprises, just the info. Here's the arc. Guys, my name's Ryan. I'm a divorce mediator. This is general information, not legal advice. Talk to your lawyer specifically about you and your jurisdiction. Okay, so generally, during a mediation session, as you reach agreements on the house, the bank accounts, the kids, we document them. Meaning you jointly document them with the mediator facilitating that conversation. You write, you're the scribes. Could be a shared Google Doc. Do you agree with this language? Do you agree with the wording? Yes? Okay, great. You guys are agreeing. Great, you're building it live. And this is compiled into often what's called a Memorandum of Understanding, okay? It's a detailed record of the decisions that you're collectively making, written by you guys collaboratively. Now, at this point, not legally binding. Why? Because a court hasn't signed it, right? To make it legally binding, hasn't signed and stamped it. And this, I think, is notwithstanding that people want to get it done and they want it signed and they want to move on and they want to fish it. That's great. I think that this is a feature and not a bug of mediation because you now have time to think about this and review everything. And if you want to have a family law attorney review it, or an uncle or a financial advisor or a tax advisor or a sister or a brother, great. Not necessarily to blow it up, just to make sure that you understand the legal implications, the financial implications, the tax implications of what you just agreed to, that you didn't miss anything. And I think that that's great because down the road, the long-term consequences are that because you felt the process was fair and informed and at a reasonable cadence, that will stick with you more. You'll resent it less. You'll follow the agreement more, and there'll be net less conflict downstream. Okay? Then here's where you go to either DIY self-filing or you go to the court. You go to the attorneys to draft and file an agreement per the jurisdiction that you're in, per the conventions, per the rules in the statute, to give ultimately to a judicial officer, to a judge, etc., who then, broadly speaking, reviews it. If everything looks good, if it meets state requirements, if it passes legal muster, then let's suppose hypothetically the judge signs it, and that's your proverbial divorce decree pending the language of whatever jurisdiction you're in. And that is a court order. That is legally binding. That violations are enforceable. That has remedies. And again, I just want to point out, I've said this in other videos, I think this footnote is really interesting, that the compliance research here shows that the people who have mediated agreements follow them more than the people that have court-imposed orders from litigation, right? And the intuition is, the logic behind this is simple, is that because you built the agreement, you own it, and you know why every provision is in there, and you're more likely to honor it because you helped create it. So, what did we learn in this video? Mediation agreements and mediated memorandums of understanding can become legally binding in a fairly predictable process, and they tend to get followed more often than court orders. But there is a process to get them there. It just doesn't happen right outside of mediation. So guys and gals and everybody's, flannelpeoplemediation.com, free consultation. Bring your questions about process. I'm happy to talk. My name's Ryan. I'm a mediator. Thanks for watching. Share, like, subscribe, and have a great day.